Supplementary list, item number 1.
Good morning, Your Lordship. So item number 1 was supplementary list. An application has been preferred, a bail application on behalf of one accused who was arrested in connection with a UAP matter in Nongpo. He's been in custody for over 1 year, 4 months as on date. Lordship, I would like to take your honor's attention to the FIR. So what had happened was there was a bomb blast in Shillong. Thereafter, when an interrogation was made into by the investigating officers of this particular case in Shillong, and information was given to them by the arrested accused persons that 2 individuals from Nongpo may also be involved in similar activities. Thereafter, an arrest was made of a co-accused person in this particular case, Damanbhar Ripna, from whose vehicle explosives were recovered. Now, the person on behalf of whom the bail application has been preferred was not to be found along with the person from whom explosives were recovered. And in the petition, Your Lordship, I have averred that there has been non-compliance of a statutory provision, a constitutional mandate. Besides that, there is no evidence against Mr. Rovinus Ripna. And also certain other things, we'll deal with them one by one, if I may. So, right, Your Lordship. So the accused person, Mr. Rovinus Ripna, this in connection with the instant case, was arrested on the 12th of March 2024. Before we 43
Arrested on?
Lordship,
Arrested on?
12th of March 2024. FIR filed 11th of March 2024.
FIR?
Filed 11th of March 2024.
Okay. Yes.
Lordship, before we actually start delving into the particular matter, it is incumbent upon me to inform the court, like we have rigors of section 37 which applies to cases under the NDPS Act. Similarly, under section 43D also there are certain restrictions.
They are paramaterial.
Absolutely. Now, despite of that particular fact that there are restrictions to grant a person bail, his case for bail will still be made out for this particular individual. Now, why I say so, Your Lordship, is because of non-compliance of section 43B of the UAP Act. If it may be placed, I'll just read it out. Can I be?
B.
Subsection 1.
Yes.
Yes. So 43B subsection 1 says, any officer arresting a person under section 43A shall as soon as may be inform him of the grounds of such arrest. In simple and short terms, the grounds of arrest were never communicated to the accused person in question, either in writing or orally. Now, whether non-compliance of this particular mandate or statutory mandate under the UAP Act entitles him to bail, yes, it does. There was a recent observation, well, not recent, Your Lordship, but it was delivered on the 15th of May 2024 in Prabir Purkasta's case, when the Honorable Apex Court held that the grounds of arrest, as per the statutory mandate of 43B, must be communicated to the accused person of his copy in writing. Circle a copy. Circle. In writing. This is Prabir Purkasta. The citation is 2024 8 SSC 254. SCC 254. Sorry. 254. Shall I continue?
Yes.
So what had happened in this particular case, Your Lordship, Prabir Purkasta's case? Now, like I had informed Your Lordship that the matter which we're dealing with, 43D applies to this particular case because of one particular section which falls under Chapter 4. Similarly,
Para?
in this,
You're quoting what?
I'm not quoting any, so I'm just mentioning that even in this particular case, one of the sections fell under the rigors of section 43D. So similarly, what I'm just trying to say is this case also attracted the rigors of 43D. Yet the Honorable Apex Court held that despite of the rigors, the accused is entitled to bail because of non-compliance of 43B. Let me take you to the relevant paragraph, Your Lordship. Paragraph 17 of the said judgment.
Paragraph 17.
which Your Honor will find at page number 22. 17, 18, 19, 20. You'll have to read paragraph 17 to 22, Your Lordship, of this particular judgment.
Yes.
17, 18, 19, 20 till 22. Before I start reading, it's also incumbent upon me to inform Your Lordship that the observation made in this particular judgment, UAPA case of course, was reiteration from Pankaj Bansal's case. Pankaj Bansal dealt with a PMLA case, wherein the Supreme Court had also observed that grounds of arrest must be communicated in writing. Same observation was made in this particular case, that even in UAP cases this thing applies. So I'll just start reading here from paragraph 17. Upon a perusal of the statutory provision reproduced above, statutory provision meaning 43B, which I just read out, we find that there is no significant difference in the language employed in section 19(1) of the PMLA and section 43B(1) of the UAPA, which can persuade us to take a view that the interpretations of the phrase inform him of the grounds of writing for such arrest made by this court in the case of Pankaj Bansal Supra should not be applied to an accused arrested under the provisions of the UAPA Act. We find, underline here, we find that the provisions regarding the communication of the grounds of arrest to a person arrested contained in section 43B(1) of the UAPA is verbatim the same as that in section 19(1) of the PMLA. The contention advanced by the learned ASJ that there are some variations in the overall provisions contained in sections 19 of the PMLA and section 43A and 43B of the UAPA would not have any impact on the statutory mandate requiring the arresting officer to inform the grounds of arrest to the person arrested under section 43B(1) of the UAPA at the earliest, because as stated above, the requirement to communicate the grounds of arrest is the same in both the statutes. As a matter of fact, both the provisions find their source in the constitutional safeguard provided under Article 22(1) of the Constitution of India. Hence, applying the golden rules of interpretation, the provision which lays down a very important constitutional safeguard to a person arrested on charges of committing an offence either under the PMLA or under the UAPA have to be uniformly construed and applied. Paragraph 19. We may note that the modified application of section 167 of the CRP is also common to both the statutes. Thus, we have no hesitation in holding that the interpretation of statutory mandate laid down by this court in the case of Pankaj Bansal Supra on the aspect of informing the arrested person the grounds of arrest in writing has to be applied pari passu to a person arrested in a case registered under the provisions of UAPA. Paragraph 20. Resultantly, there is no doubt in the mind of the court that any person arrested for allegation of commission of offences under the provisions of UAPA, or for that matter, any other offence, has a fundamental and statutory right to be informed about the grounds of arrest in writing, and a copy of such written grounds of arrest have to be furnished to the accused person as a matter of course and without exception at the earliest. This is what I am trying to impose upon. I'll just read because the purpose of informing to the arrested person the grounds of arrest is salutary and sacrosanct, inasmuch as this information would be the only effective means for the arrested person to consult his advocate, oppose the police custody, remand, and to seek bail. Any other interpretation would tantamount to diluting the sanctity of the fundamental right guaranteed under Article 22(1) of the Constitution of India. Para 21. The right to life and personal liberty is the most sacrosanct fundamental right guaranteed under Articles 20, 21 and 22 of the Constitution of India. Any attempt to encroach upon this fundamental right has been frowned upon by this court in a catena of decisions. In this regard, we may refer to the following observations made by the court in the case of Roy V.D. versus State of Kerala. The life and liberty of an individual is so sacrosanct that it cannot be allowed to be interfered with except under the authority of law. It is a principle which has been recognized and applied in all civilized countries. In our Constitution, Article 21 guarantees protection of life and personal liberty not only to citizens of India but also to aliens. Thus, any attempt to violate such fundamental right guaranteed under Articles 20, 21 and 22 of the Constitution of India would have to be dealt with strictly. Lastly, the right to be informed about the grounds of arrest flows from Article 22(1) of the Constitution of India, and any infringement of this right would vitiate the process of arrest and remand. Mere fact that a charge sheet has been filed in the matter would not validate the illegality and the unconstitutionality committed at the time of arresting the accused person and the grant of initial police custody, remand to the accused person. So I'll stop here. Lordship, I'll stop here. I've underlined a lot more paragraphs, of course, but I'll be read out accordingly. So I'll just stop here. So I'm imposing upon the court that it is incumbent upon the investigating agency, it's a statutory mandate, of course, that the grounds of arrest must be informed to the accused in writing. That has also been held here. Now, has the same been done so in this case? It has not been done so. Now, what we must look upon, Your Lordship, are the documents associated with the arrest and remand of the accused person. So I'll take you to annexures 2, 3, and 4.
Page.
Annexures 2, 3, and 4 are at page 13, 14, 15, 16 respectively, and 17. Okay. So annexure 2 is at page 13, Your Lordship.
Yes.
There's a document associated with the arrest, which is the arrest memo.
Yes.
All I'm trying to impose upon Your Lordship is this is the first document which is prepared when a person is arrested. If you read the arrest memo, the first page, which is page 13, we find that the grounds of arrest are not mentioned therein. We turn the page and go to page number 14, and we find that the grounds of arrest are not mentioned herein as well.
Page 14.
14, which is of the arrest memo. After a person is arrested, a forwarding report is prepared, which is at annexure 3, page 15.
This is a prepared format.
It is a prepared format. It seems it's handwritten. They've mentioned his stature, his height,
True.
etc., the details, but they've not mentioned the grounds of arrest.
Where is the the slot where grounds of arrest is required to be?
Absolutely, it's missing.
No, this is done generally, isn't it?
Generally, but again, grounds of arrest are individual to every person.
True. Grounds of arrest. But how was those grounds? How are those grounds to be?
No, they were never communicated.
To be conveyed to the any arrested person.
Right. So
There's
it can.
No format.
No. So it's like this because in this particular judgment later on, I'll also get to this paragraphs, when it is stated that the grounds of arrest are to be communicated in form of writing when the person is arrested. So it can be given to him in writing, grounds of arrest, or a copy of the forwarding report can also be forwarded to him, wherein grounds of arrest must be mentioned.
Okay.
And thereafter a copy can be given to him. So that is how grounds of arrest in writing are to be communicated. So we see the arrest memo, Your Lordship. We don't find the grounds of arrest mentioned there. We move to the forwarding report.
Yes.
The forwarding report starts with the brief facts of the case. Second paragraph,
Yes.
further inquiry was made, etc., etc. Again, speaking about the investigation. Third paragraph speaks about interrogation done of the accused from whom the explosives were recovered. And ultimately, the concluding paragraphs, which are at page number 16, the IO just simply prays for grant of police custody. So the grounds of mention are not mentioned here in either.
Yes.
And the last document, Your Lordship, which deals or which is associated with arrest and remand, is the first order of remand, which I've annexed at page number 17 as annexure 4.
Yes.
Now this is order dated 12/3/2024. This is the first order of remand, Your Lordship. I'll start in a gist. Your Lordship, I'll just state that herein also it has not been mentioned that the grounds of arrest were ever communicated to the accused persons either verbally or in written. Although the mandate is it should be communicated in writing.
Yes.
Shall I read out the order, Your Lordship? It's fine. Because the order, at least if the grounds of arrest were communicated at any point of time, it should have been reflected in the order sheet, but it's not done so.
Okay.
Now, on account of these particular documents associated with the arrest and remand, it can safely be concurred, Your Lordship, that the grounds of arrest in this particular case, in this instance, were never communicated to the accused persons in writing. I have read out the relevant portions, Your Lordship, which state very clearly that it must be done so. If it is not done so, it vitiates the process of arrest and remand. Let me take Your Honor's attention also to paragraph 49 of the said judgment.
Yes.
Okay. So we'll read from paragraphs 49 to 52.
Yes.
Okay, I'll start reading it. Paragraph 49. It may be reiterated. Sorry. Paragraph 49, you'll find, Your Lordship, at page number 39.
Yes. Please go on.
All right. Paragraph 49. It may be reiterated at the cost of repetition that there is a significant difference in the phrase reason for arrest and grounds of arrest. The reasons for arrest, as indicated in the arrest memo, are purely formal parameters, viz. to prevent the accused from committing any further offence, for proper investigation of the case, to prevent the accused person from causing the evidence of the offence to disappear, or tampering with such evidence in any manner, to prevent the arrested person from making inducements, threat, or promise to any person acquainted with the facts of the case, so as to dissuade him from disclosing such facts to the court or to the investigating officer. These reasons would commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest would be required to contain all such details in hand of the investigating officer which necessitated the arrest of the accused.
Yes.
I'll continue. Simultaneously, the grounds of arrest, informed in writing, must be conveyed to the arrested accused all basic facts on which he was being arrested, so as to provide him an opportunity of defending himself against custodial remand and to seek bail. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated with the reasons for arrest, which are general in nature. Paragraph 50. From the detailed analysis made above, there is no hesitation in the mind of the court to reach to a conclusion that the copy of the remand application in the purported exercise of communication of the grounds of arrest in writing was not provided to the accused appellant or his counsel before passing of the remand order dated 4th of October 2023, which vitiates the arrest and subsequent remand of the appellant. As a result, the appellant is entitled to direction for release from custody by applying the ratio of the judgment rendered by this court in the case of Pankaj Bansal. Accordingly, the arrest of the appellant, followed by remand order dated 4th October 2023, and also the impugn order passed by the High Court of Delhi dated 13 October 2023, are hereby declared to be invalid in the eyes of law and are quashed and set aside. Simply put, the grounds of arrest, as observed in this concluding paragraph, can be communicated to him just before the first remand is made. Must be communicated before the first remand is made, of course, because once you make the first remand, it vitiates the entire process altogether. Now, that was not being done. That has not been done so in this particular case. I hope I've satisfied your lordship on this particular point. Wo NDPS Guwahati High Court office copy कौन सा सब हाईलाइट कर दिया lordship. So there is one more. If I may continue, when I read out paragraph 22 of this particular judgment, it had stated the communication of grounds of arrest in writing must be done not only in UAP cases but all cases altogether. Now, citing the principle laid down or the ratio laid down in this particular case, Prabir Prakash case, in an NDPS matter also, the Honorable Guwahati High Court had granted bail, citing the exact same thing, the grounds of arrest were never communicated in writing to the accused person. My endeavor, basically, Your Lordship, is just to bring before the court that even in NDPS, the rigors of 37 applies, so does here. Now, in other special acts as well, benefit has been granted on the basis of the ratio held in this particular case. I have placed, if I that may be placed before Your Lordship, it will just take me 2 minutes to read this one. I'll take you straight away to paragraph 5, Your Lordship. Further, it is submitted, this is an NDPS matter, of course. Further, it is submitted by Mr. Baur Thakur, learned counsel for the petitioner, that the grounds of arrest are also not mentioned in the notice to the accused person under section 50 CRPC, section 47 BNSS, which is mandatorily required, and non-compliance of the same is in violation of articles 21 and 22(1) of the Constitution of India. He accordingly submitted that all the full particulars of the offence which is alleged to have been committed by the accused should be informed to him at the time of his arrest, and otherwise it would be against the mandate of the Constitution of India as well as the statutory provision which vitiates the arrest itself. In this context, Mr. Baur Thakur, learned counsel for the petitioner, cited the following decisions: Vihan Kumar versus State of Haryana, reported in 2025 SEC Online, SC 269, and Prabir Prakash versus State NCT, reported in 2024, 8 SEC 254, which I have read out, Your Lordship. So I'll take you to paragraph 10.
Yes.
I've already underlined the same. It is the contention of the petitioner that non-communication of the grounds of arrest is in violation of section 51 of the CRPC, corresponding to section 47(1) of the BNSS. Even in the BNSS, Your Lordship, the BNSS would apply to this particular case.
Yes.
There is a statutory mandate which says the grounds of arrest must be communicated in writing. Nonetheless, we're dealing with a special act, of course, which specifically states the grounds of arrest must be communicated. I've read that of 43B. It goes on to say, the accused person has the fundamental and statutory right to be informed about the grounds of arrest in writing, and a copy of such written grounds of arrest have to be furnished to the arrest person as a matter of recourse and without an exception. And paragraph 11, the Honorable High Court of Guwahati quotes paragraphs which I've already read out, Your Lordship, so I'll not repeat that exercise. Paragraph 19 I read out and 21, which I've already read out, of Prabir Purkayastha. But I'll take you to paragraph 12, wherein quotations were made from Vihan Kumar's case. I believe that must be read out, Your Lordship, if I may be allowed to. Paragraph 14. Further, in the case of Vihan Kumar, the Honorable Apex Court has held under paragraph 14, thus the requirement of informing the person arrested of the grounds of arrest is not a formality but a mandatory constitutional requirement. Article 22 is included in Part 3 of the Constitution under the heading of fundamental rights. Thus, it is the fundamental right of every person arrested and detained in custody to be informed of the grounds of arrest as soon as possible. If the grounds of arrest are not informed as soon as may be after the arrest, it would amount to a violation of the fundamental rights of the arrestee guaranteed under Article 22(1). It will also amount to depriving the arrestee of his liberty. The reason is that, as provided in Article 21, no person can be deprived of his personal liberty except in accordance with the procedure established by law. The procedure established by law also includes what is provided in Article 22(1). Therefore, when a person is arrested without a warrant and the grounds of arrest are not informed to him as soon as may be after the arrest, it will tantamount to a violation of his fundamental right guaranteed under Article 21 as well. In a given case, if the mandate of Article 22 is not followed while arresting a person, or after arresting a person, it will also violate fundamental right to liberty guaranteed under Article 21, and the arrest will be rendered illegal. On the failure to comply with the requirement of informing grounds of arrest as soon as may be after the arrest is vitiated. Once the arrest is held to be vitiated, the person arrested cannot remain in custody even for a second. In the instant case as discussed above, it basically observes, Your Lordship, in this particular paragraph, in the instant case as well, grounds of arrest were never communicated. Holding the same, even though the rigors of 37 applies, the Honorable Guwahati High Court proceeded to grant bail to the individual arrested.
Yes.
Your Lordship, besides non-compliance of the statutory mandate and the constitutional mandate, there are a few other things which I have also raised in the petition. Besides this, it is also incumbent upon me to inform the court, Your Lordship, that there is no evidence against the accused person, Robinus Ripna, in this particular case. It seems that the only evidence seeking which the prosecution has filed a charge sheet against the accused person are CDR reports and 161 statements, which, as we all know, Your Lordship, are not conclusive proof. Now, I'll take you to paragraph 8, page. I'll take you to page 44 of the petition. Is there anything I'm forgetting? Page 44 of the charge.
44.
44. It's page 44 of the petition. I'm sorry.
Yes.
Is it? All right. Now, why I say so, that there is no evidence against the accused Robinus Ripna, is because when the main accused person is arrested, from whom explosives were recovered, Your Lordship, he was preliminarily interrogated by the investigating agency, and he states in paragraph 40, in the third paragraph of page 44, on being examined, Shri Damanbar Ripna confessed to his role as being a member of the band HNLC and that he had been entrusted by one person, namely Sunbar, mobile numbers mentioned, to carry out an explosion at a grocery store near Rani Motors, Downgate, Nongpo, on the evening of 10th of March 2024. But he could not carry out the task. Further, he voluntarily admitted to carrying the IED, which he had kept in the vehicle, and he was willing to lead the police team to show and identify the place where he had kept it. Now, when he was preliminarily interrogated, Your Lordship, he does not mention the name of the accused Robinus Ripna. Now, Robinus Ripna is only arrested because his number appeared on the mobile phone of Daman Baripna, from whom explosives are recovered. Now, their nephew and uncle, Your Lordship, a conversation between them is a natural course of business. They do communicate with each other. The investigating agency has also relied on the call detail report of these two individuals, and I'll take you to page 54 of the petition.
Yes.
So page 54 of the chart sheet, page 54 of the petition is basically a page from the chart sheet, of course. This is a part of the chart sheet, a page from the chart sheet. Now page 54 shows this call detail report between Daman Bhai Ripna and Robinus Ripna. The bailiffs refer on behalf of Robinus Ripna. Daman Bhai is the person from whom the explosives were recovered, allegedly recovered. I'll take you to the last portion, Your Lordship, of page 54. Now, the report which you see before you is the call detail report of these two individuals. A party is Mr. Daman Bhai Ripna.
You're referring to
I'm referring to
last paragraph.
last paragraph. There is a chart, Your Lordship.
Frequent contact.
Yes, Your Lordship. The frequent contact between him and the other accused person as a precipra. So A party
Yes.
is Daman Bhai's number and B party reflects Robinus's number. I'll take you to the last entry, Your Lordship. Last entry, as you can see, the numbers are mentioned 9366347208. Now this belongs to Daman Bhai as per the chart sheet, and 923307396962 belongs to Robinus. And Your Lordship, if you see the call duration, it is just 21 seconds. Thereafter, I'll take you to page 55, Your Lordship. Another call between these two individuals. First entry is of 88 seconds. Then second, third, fourth, fifth, sixth, the seventh entry again is between these two individuals, which is of 57 seconds. And the second last entry.
Yes.
And the second last entry, Your Lordship. Second last. That is of 16 seconds. Now, on the basis of this call detail report, the prosecution is prosecuting. The investigating agency filed a charge sheet against the individual Robinus Ripna. Lordship, the one question he asked, I even raised this before the Honorable Trial Court when the CC was done. In such short spans of time, the longest call between them being of 88 seconds, can a conspiracy be hatched? It cannot. And this is the only evidence, or basically the only document, which is being relied upon by the investigating agency to prosecute Mr. Robinus Ripna. And most interestingly, Your Lordship, the investigating agency also went to the extent of obtaining the customer application form of Mr. Robinus Ripna. Customer application form is basically a form in which the number given to a particular person is reflected, which is at annexure 11, page 79, Your Lordship. This is the last document I'll be relying on.
Yes.
Right, Your Lordship. Where is the paragraph? So I'll take you to paragraph 19 of the petition as well before I refer to this. Paragraph 19. Okay. Paragraph 19, if I may so read. Okay. That even if the CDR report is analyzed in which the details of the conversation between Daman Bhai using phone number 9366347708 and Robinus Ripna using phone number 9233073962 is given, one would find that the conversation between them are very short. I've already showed that particular point, Your Lordship. What I want to impose upon is the phone number given by the investigating agency, which is 9233073962, which it says was allegedly used by Mr. Robinus Ripna. But the customer application form, which is being relied upon by them, shows that this number does not even belong to him. If you see the customer application form, the last page of the petition, Your Lordship, Your Lordship will find the very first entry, which is mobile number.
Yes.
The very first entry. It says that the mobile number which was given to him and which was registered under the name of Robinus Ripna is 9612988507. Completely different from the number allegedly to have been used as stated by the investigating agency by Robinus Ripna.
Where is it noted?
The very top, Your Lordship. The very top. mobile number, left hand side, mobile number. There are two more mobile numbers mentioned thereafter, but those are numbers of witnesses who are, I believe it is customary for people to witness. Uh,
9.
Lordship,
What's the number here?
the number which was given to him is at the very top, Your Lordship, on the left hand corner, 9612985007.
612.
Yes, Your Lordship.
Why was it crossed out?
I do not know, Your Lordship. Perhaps it's a mandatory norm where that is how they retain the customer applications form. But apparently this number and the number allegedly to have been stated by the investigating agency which was used by Mr. are completely different. So even if the trial does proceed, I will always say that the number which you have stated to have, well, which you have alleged to have, which you are alleging that I used, I was never registered in my name. You're relying also on a document.
He may have two mobile numbers.
No, but then there is nothing on record also to show that this particular number which allegedly has been used by Robinus belongs to him. That has not been brought on record. One customer application form has been brought on record, Your Lordship, which is the one I have annexed. No other customer applications form are there on record which show that this number belongs to Mr. Robinus. Lordship, other thing is one more aspect which I've stated there in the petition is that now the accused person has been in custody for almost 1 year and 4 months, and the case is at the stage of framing of charges. There's one last authority I would like to rely on. So, this authority is from 2024, passed in Atharv Praveen's case.
Yes.
Lordship, I'll take you straight to paragraph 32 of the said judgment. Only paragraph 32 I'm relying upon, which is at page number 25.
Yes.
I'll start reading, Your Lordship. The appellant was arrested on 12 July 2022. He has undergone custody for more than 2 years and 4 months.
Para again?
Para 32, Your Lordship. Sorry.
32.
Para 32, which is at page number 25.
Yes.
Right, Your Lordship. We'll continue.
Yes.
Para 32. The appellant was arrested on 12 July 2022. He has undergone custody for more than 2 years and 4 months. Charge sheet was filed on 7th of January 2023. But till date, charges have not been framed, which is an admitted position. There are 40 accused and 354 witnesses cited by the prosecution to be examined. There can be no doubt that the trial is not likely to complete soon, and as has been laid down by various judgments of this court, as has been referred to above, the appellant cannot be allowed to languish in jail indefinitely, and that too without a trial. If such an approach is followed, Article 21 of the Constitution of India would stand violated. The ratio as laid down by this court in Union of India versus K. Najib, as also the other judgments in Javed Ghulam Nabi Sheikh versus State of Maharashtra and Thwa Fazil versus Union of India, would be applicable to this case and would squarely apply, entitling the appellant for grant of bail. The accused is similarly situated, Your Lordship. Although he's not in custody for 2 years, he's been in custody for 1 year, 4 months. But still, I believe that's a significant period of incarceration, and the charges are yet to be framed. Now, a total number of 31 witnesses have been cited by the investigating agency in this particular case as well. So that would also take a significant time to complete, Your Lordship. Let's verify if it's 31. Your Lordship, I have pleaded various things during this course. Primarily, I've pleaded that the constitutional mandate, a statutory mandate under Section 43B of the UAP Act has been flouted, which alone entitles the accused person to the benefit of bail. However, besides that, there are also other things which I just raised, Your Lordship, like no evidence being there on record against the accused Robinus Ripna, and this particular fact that the case is still at the framing of charges stage. Hence, considering all these aspects, Your Lordship, I humbly pray for the benefit of bail to be extended. That is all.
Charges have not been framed.
Not yet. कोर्ट्स में देखो कितना देर हो गया चार्जेस नहीं हुआ.
25. 25, May 25.
Yes, Mr. Kumar.
Yes, my lord. Lord, my friend has submitted three arguments, my lord. One, that ground of arrest has not been informed of, and that entitles him to bail, my lord. That is one ground. Second ground which he has urged before your lordship, that there is no prima facie material against his client. These are the two grounds which he has been urged, my lord. And before I take to the merits of the case and grounds of arrest, my lord, what I can place before your lordship, two things, my lord, that the requirement of UAPA Act, my lord, if your lordship will kindly see the Act 43D.
Excuse me.
Yes.
And 43D, my lord, 35. 43D 35, my lord.
Three five.
Yes, my lord. Your lordship has section 43, capital D,
Yes, yes.
capital D, subsection 5.
Yes.
UAPA Act. And lordship has got the copy, my lord.
Yes.
Kindly see. Notwithstanding anything contained in the code, no person accused of an offence punishable under chapter 4 and 6 of the Act shall, if in custody, be released on bail or on his own bond, unless the public prosecutor has been given opportunity of being heard on the application for such relief, provided that such accused person shall not be released on bail or on his own bond, if the court, on a perusal of the case diary or report made under 173 of code, is of the opinion that there are reasonable grounds for believing that accusation against such person is prima facie true. So, if the charges against the accused person on the basis of perusal of charge sheet, my lord, lordship comes to the conclusion that they are prima facie true, my lord, he will not be entitled to bail. That is the mandate of the law, my lord. Now, because the entire charge sheet and everything is not there, my lord, only partial charge sheet is there.
Complete charge sheet.
The statements of the witnesses, all those are not there.
Everything
Because
is here.
only limited witnesses statement, all those are not on record, my lord. We'll place it on record. We'll put it on record. But briefly, if your lordship will see, the charges also, my lord, what my friend has read, and I just see, he read one part of the charge sheet before your lordship. Kindly see that page 44 also, my lord.
Yes.
Page 44, preliminary examination. Your lordship, the heading is, my friend has read the first paragraph, my lord. Preliminary examination, page 44. On being examined, A1, Sri Damanbha Ripnar confessed to his role as being member of the band HNLC and that he had been entrusted by one person, namely Sunbar mobile number so and so, to carry out explosion at grocery store near Rani Motor Downgate, Nongpo, on the evening of 10th March 2024, but he could not carry out the task. Further, he voluntarily admitted to carry the IED which he had kept in the vehicle, and he was willing to lead the police team to show the identity of the place where he had kept it. It is to be noted that in the meantime, a missed WhatsApp call has been received on the mobile number of A1 Sri Danbha Ripnar from person named Sunbor bearing WhatsApp number so and so, wherein A1 Damanbha Ripnar revealed that this is the person who has been speaking with and who directed him to carry out the bomb blast on HLC. A1 Damanbha Ripnar willingly agreed to talk to him in front of team and to record the conversation with him. Accordingly, a video recording of the conversation was done. Under the spot, the willingness of A1 of Damanbha Ripnar. All these statements are what I am trying to show. All these statements are required to be placed before your lordship to ascertain whether prima facie case is made out against the accused or not. At this stage, Your Lordship may issue notice, we will file the report and status report and all the matter, including we will meet the charges, because charge sheet has already been...
Notice you have already under appearance. What notice is required?
In this sense, I accept notice, my lord, and I will file the status report. Because formal notice, I'm sorry, my lord, I may not be familiar with the process.
You see, you know very well. You see,
Yes, my lord.
if you have voluntarily appeared,
I have appeared, my lord. Yeah, that I have to appear in these matters, my lord.
that is the
Yes, my lord.
notice.
So
No formal notice is required.
yes, formal. I am not saying formal. I accept the notice,
Now,
my lord.
okay, that part is done.
Correct.
Now, as mandated by Section 43D,
Yes.
You have been given the opportunity to reply to his
Yes, my lord.
contention or submission.
Yes, my lord. I'll file the report. I'll file the report and I will meet, because my friend is raising the
What
argument.
report? See, the
Charge sheet I have to file.
The fact remains that charge sheet have been filed.
Yes, my
Only
lord.
charges to be framed.
Yes, my lord.
Court,
that-
the trial court has not yet.
Yes, my
proceeded
lord,
to
but
that extent.
framing of charges will or non-framing of charge will not entitle him to bail.
true,
What will entitle him to bail is finding by your lordship that no prima facie case is made out
Yes.
after perusal of the charge sheet, my lord. That is the legal
Charge sheet is charge is only.
process. Charge sheet only the only limited portion. Statements are not there. All those records are not there, my lord. I have to file the entire charge sheet before your lordship. And kindly see one more aspect, my lord, that his role, which is also described, my lord, at page 74, because those are only limited things which I have got today, my lord. I will place every statement, everything where his role is there, showing he is ex facie involved in the crime, my lord. Not prima facie, ex facie, because charge sheet has been filed, my lord. Once that is there, my lord, then my submission is that embargo under 43D5 will come into play and he will not be entitled to bail, my lord. That is my submission, my lord. Let me file the charge sheet.
If you recall, in one of the judgment he has cited.
Yes, my lord.
Supreme
That
Court-
Purkastha judgment.
Yes,
Purkastha
Yeah,
judgment.
the Supreme Court did say even if charge sheet has already been filed,
Yes, my lord.
you
That
would still be entitled to that.
yes, my lord. So the question, my lord, is that whether that ratio, because in that case no charge sheet. If that is the case of offence under the PMLA, my
No,
lord.
sir, that was on a UAP.
I sorry, and the other aspects are also required, because judgment has been supplied to me. I will go through, because there are judgments now of the various high courts showing that that region may not apply retrospectively also, because the judgment their Kerala High Court ruling also on this issue, my lord, which says that the judgment of Honorable Supreme Court in Purkastha will apply prospectively. That is also, so I will place all these materials. It's an interesting question, because all other issues will come up for your lordship's consideration in similar matters. So a authoritative decision by this court on this issue will be required, my lord. So I need to place all these materials, including his role, my lord. If I have to show briefly his role at page 74, I will place everything, my lord, in detailed charge sheet.
Fine.
If I may,
We'll take up the matter on Tuesday.
Lordship, just a few moments,
Tuesday
if I
will
may
be too
begin.
short, my lord. Your lordship may have it on 10th, my lord. 10th of
10th. Why not 8th?
Lordship,
See, the boy here is not. What is there?
No, actually, I'm having
have
some
2-3
difficulty
days.
on 8th, my lord. 9th, 10th, 9th, 10th, any date, my lord. 9th, 10th. 10th, your lordship may have, because 9th we have got so many hearing matters on.
9, we have DV also.
Oh yes, my lord, also. Or your lordship may have it on 11th also, my lord.
11 would be a little too far, you know.
Not, it's only 1 week. And 1 week.
Lordship,
Where issue of liberty is concerned.
Liberty is 1 day, but your lordship will have to see his role also. And 43, because liberty, this person has filed the bail, my lord.
Considering the seriousness of the offence,
And if it was so serious, my lord, he has filed and withdrawn also. He has not disclosed that fact also.
no, I did, your lordship.
Because now he has filed, because if he has filed and no new ground is being made out for the bail, my lord, because that argument will also be there, my lord. You withdraw for filing a fresh, then you have to show that new ground has arisen after withdrawal, my lord.
Lordship, when I withdrew the application, I
And
had
that
sought
is
liberty to
26.
file
So
it afresh.
liberty
of
will
wrong
be
election.
only in accordance with law, my lord. Liberty in accordance with law, and liberty means That law requires that if you have something new after 26 June, then only you can proceed with the new.
I had sought fresh filing based on wrong annexures.
The brace, because you have to.
Liberty was granted, so.
But my lord,
When open court had
liberty,
said I've annexed
I will
wrong
place the judgment. Liberty does not mean that liberty against the law. Liberty is always in accordance with law. If you withdraw the petition and then there is no new ground, there are series of judgment, my lord. I will place all those case laws before your lordship where the law is liberty does not mean liberty contrary to law. Liberty does not mean unfettered liberty. Liberty means as per the law, as per the constitution, as per the mandate of law. I will place that. Yes, that. And one more thing, my lord, there is one more technical issue which my friend should correct it. Now, petition has been filed by the wife of the accused. Now, the law is, my lord, that accused will file the petition and wakalatnama will be by the accused and wife will, parokar will file the affidavit, my lord. Because what happens, my lord, we challenge the order. Before the Honorable Supreme Court, in one of the matter also, we have challenged the order, my lord. So, what happens, wife is not, the accused is not before your lordship. So, therefore, the case title should be in the name of the accused person. Accused is seeking the bail. It's not accused is seeking the bail, so he should come before your lordship. His wife, because he is in jail, so therefore affidavit will be filed by the parokar, my lord. That is the problem which I am facing in other matters also, where the relative is filing the case, accused is not before, so accused is not seeking the bail, my lord. My argument is, where is accused is not before your lordship.
See, perhaps we'll have to see the principle of next friend.
So that the principle I will place the because that issue has to be resolved here, my lord. Principle of next friend will apply in the case of minor, not in the case of major, because right now accused is not seeking bail, my lord. Wife cannot, the accused can seek bail before your lordship. He is competent to seek bail, my lord. He is not seeking bail before your lordship. He is not coming against the charge sheet, my lord. Wife is coming, brother will come, because that principle will not apply in these cases, my lord. Here, because I have been filing cases time and again, where in all cases the requirement is, even in Supreme Court rules, etc., requirement is the case is filed in the name of the accused. The wakalatnama is also signed by the accused in the presence of the superintendent of jail. The affidavits are filed by.
Mr. Kumar, if you wish to challenge the maintainability.
Yes, I would like to. I will file a short reply on that point.
File a response. File an affidavit.
Yes, my lord. I will file a
with advance copy to him.
Yes, I will do that, my lord.
And you respond to that.
Yes, because that is an issue.
We have honestly wasted so much time only on this.
My friend has been placing the judgment. If I would have interrupted, he said you are interrupting me. I would have.
You could have at least.
My friend was trying to make out a case.
You could have cautioned the court that this is what you intend to do. Now.
No, because ultimately when my turn, if I argue, they say that you don't allow me to argue.
So, but you say the matter is sub judice, isn't it?
Which matter is
this particular thing that it should be signed by the accused person?
Yeah, there is rules there. There is not. I will place that.
You don't have it.
I'll place.
We have been okay. Anyways,
I'll place.
Then we'll list this matter on 15th.
50.
And before that,
yes,
you give an advance copy.
No, 14th is holiday, my lord. 14th is holiday. 16th, your lordship, so that 15th they will get it.
Lordship, I believe 15th or 16th.
He'll give you an advance copy.
Right.
On the issue, on the point of maintainability, and you respond to that.
We'll take it all together then. The hearing of the.
Either you file your response before the next returnable date.
Right, Lordship. Lordship, if I may so request, he's already been in custody for a considerable amount of time. 15 and 16 will be a little too far. If he can have it next week.
1 week is in UAPA matter. In UAPA and your role is there, your mobile phone is there, conversation is there, and you have withdrawn it, my lord. You have withdrawn on 26th.
Taking into account the fact that they will firstly have to file if they wish to, as has been
indicated.
He'll file a objection on maintainability.
Right, right, your lordship.
You will respond to that. So you have to file your response, and the court will take cognizance of the same on the next returnable date, without having to pass an order, wait another 1 day, 2 days, 1 week for you to respond. So that would not be to your advantage.
Yes, ma'am.
Right.
So 15 or 16 would be good enough. You decide on the date. 15th?
16th, Your Lordship, may be,
No,
because
Mr.
14th is not
Mr.
working.
Mr. Kumar.
So we'll have to serve a copy on this. Affidavit is required.
Yes, so you have to serve a copy to him by 9th. And he will respond by, his response will be filed by 11th.
Will do, Lordship.
That will be taken out 15th.
15th is a Tuesday, Lordship. Yes. Yes.
Tuesday, yes.
Tuesday is good enough.
Tuesday.
That's all. So if it does start it, I think this would be the first case in which this objection is being raised. I don't know if it's been
No,
raised.
no, the law is law. First case or last case.
Right, no problem. No, I'm just saying on a lighter note.
Heard Mr. S.S. Yara, learned counsel for the petitioner,
It's on a Tuesday.
who has submitted that the petitioner being the wife of accused person named, where is the name of the accused person?
Robinus Ripnar, Lordship. Robinus Ripnar.
Robinus Ripnar.
Ripnar.
Robinus Ripnar,
Oh, petition.
who was arrested on 12/3/2024 in connection with Longpo PS case number 25/3/2024 under section 120B, ini ke paragraph 2 ni mah. Paragraph 2. Act 2. The case on being investigated has resulted in the investigating officer to file his charge sheet, upon which the learned trial court and upon which the learned special judge under bracket UAPA capital no close bracket Nongpo Viboy district has gained cognizance of the same, and eventually where is the case number?
UAP case number 1 of 2024.
The last line. UAPA case number 1 of 2024 has been registered with the accused person in question as one of the accused therein. Accused person therein. Next, the learned counsel has also opened this case by citing the facts of the case and has went on to submit that the accused person in question has been falsely implicated in the case, and more particularly the statutory provision of section 43B, capital B, particularly 43, where is that section you say?
B. 43B, Your Lordship.
43B.
B subsection 1.
Subsection. No? And more particularly section 43, subsection 1 of section 43B have been violated for the authorities, for the arresting authorities failing to inform the accused person of the ground of his arrest. the next contention of the learned counsel is that there are no evidence on record to implicate him as far as the alleged offence is concerned. And finally, the fact that the accused person has been in custody for about 1 year, 4 months.
Almost 1 year, 4 months.
Almost 1 year, 4 months, such prolonged incarceration would entitle him to be granted bail on account of delay in trial. Next, Mr. A. Kumar, learned AG, responding to the submission made by the learned counsel for the petitioner, has at the outset raised preliminary objection on maintainability of this application. The learned AG has also submitted that the prosecution, that the state respondent may be allowed to produce the complete charge sheet and other relevant materials for this court to be apprised of the exact facts and circumstances of the case of the accused person in question. And for this, some time is prayed for such objection, for relevant objection to be placed for this court by way of an affidavit. This court has considered the submission made, and as regard the initial objection raised by the learned AG on the issue of maintainability, the prayer made for filing of a written objection in this regard is allowed. It is, however, made clear that the said response be filed within the next returnable date, with advance copy to be furnished upon the petitioner, who will then file his reply if so advised. As agreed to by the parties, this is matter on 15th July for further hearing. I will not note down when you are to file. I think that you should do.
Yes, we'll file it.
We'll coordinate.
Yeah. 15.
15th it's fixed.
15.
Take a leave, Lodge. Good evening.
Item number 2.
Lordship, before this part, the item number 2 is taken up. This main course list, item number 1 to 7. If this matter may be taken on another day, I think it seems that this matter will take some more time now. And the leading counsel Andy Shola also today he is not available. So if this matter can be taken up next week, Your Lordship.
You should have asked, for adjournment in the first in the mentioned period. Why?
Sorry, Your Lordship.
Who's for the petitioner?
I am for the petition, Lordship.
But you are in some cases. In some cases, you are petitioner, or you are petitioner for.
In all 7, Lordship.
What do you say?
Okay, Lordship, because my Lord, because the item number 2 will take time, Lordship.
It won't take time. Mr. General has finished his argument. He needs only 1 minute. Why?
Yes, Lord, since the other side is saying no problem next week. Lordship. 1 week or 2 weeks, then make it 2. Then make it 2 weeks, Lordship. Then
Why 2 weeks?
1 week.
After 1 week,
One
Your
week.
Lordship.
All matter.
1 week, Lordship.
1 week will do, Your Lordship.
Mr. H. Abraham, Leonard GA has sought for accommodation on the ground that the Leonard EAG, Mr. Indishulai, is indisposed. For the state respondent, no? Mr. S.A. Sheikh, Leonard Counsel for the petitioner, has no objection to the preamble. Allowed. As prayed for, this is matter after 1 week.
I reply, Your Lordship.
Yeah, please, Your Lordship. In this matter, I am appearing for 4 and 5 respondent number.
Any objection? No. Then just a moment. Under next को भी काफी है. नहीं कहीं इतने. Just a moment, Mr. General. We'll call you. Okay. Just finish this number 8. Call the number 8.
Item number 8. May it please Your Lordship. Your Lordship, I am praying for some accommodation in this matter, Your Lordship. Senior counsel has some personal difficulty today, Your Lordship.
Where were you during the mention period?
Your Lordship, I had asked someone to mention. Your Lordship, I apologize, we missed the mention.
So, Mr. Kumar,
Personal difficulty.
how much cost do you want?
Then I will also have to pay cost, my lord, in other matters.
We'll give you a cup of tea. On premier by petitioner, and objected to by respondent, place this matter after 2 weeks.
Much obliged.
Yes, Mr. General.
सबको भगा दिया क्या करेगा आपको देखते लगते हैं Lordship,
Yes.
on the last occasion I have pointed out that the learned court below has discarded the evidence of CW2 and CW3 on the ground that CW2 in his examination in chief, he said that he was seriously injured, and in the cross-examination he said he was badly injured, and therefore the court says that his testimony is contradictory in itself, and so far the other witness is concerned.
Who is CW3?
CW2 is an eyewitness who was present with the deceased sitting beside him.
Okay. He was a co-passenger.
He was a co-passengers. Another witness examined by the claimant, CW4, he has also narrated the manner into which the accident took place, but his evidence was also discarded by the learned court below on the ground that at one place he says that he has reported the matter he has informed to the police, and in other place he says that he has not done it, and therefore the court has rejected both the evidence of the eyewitness so far the claimant is concerned, and found that the evidence of the police official is more reliable than the evidence of the CW2 and CW4. And in that view of the matter, the learned court below has dismissed my claim application in toto. on the ground, on the finding that
Negligence is fastened on the driver.
and driver. And there is one more observation which has been made by the trial court below. Your Lordship will see page 140. Paper book. 140, paragraph 61. Paragraph 61 also
There's just one
140.
140.
Yes, Lord.
This one. Para 61.
61.
Yes.
I'm not able to make it out whether this is an observation or it is a finding. Para 61. Also, as per paper mark D, there was smell of alcohol detected on the disease, Your Lordship. Now, this is, according to my understanding, this is not a finding, this is only an observation. Finding is on page number, paragraph 62, 60, 63, 64.
Any medical report?
Yeah,
This is the medical report.
there is a postmortem, and the driver and the person who conducted the postmortem was not examined. I'll deal with this. But I wanted to point out that this was not the finding of the court which was taken into consideration for the purpose of rejecting or dismissing my claim application. Now, Your Lordship, in order to ascertain the things, we have to see what was the pleading of the parties before the court below. Your Lordship, page 3, paragraph 8. Paragraph 8. Nonco, that place, date and time of accident.
Yes.
Nonco proper GS Road, below Nonco PS RI Revai district on 11/6/2014. Your Lordship will note here the accident took place 11 years before. 11 years before.
Yes.
Under Nonco PS, the matter was reported to Nonco traffic branch by GD number so and so. The police had wrongly registered a UD case bearing Nonco PS UD case. Your Lordship, so far this fact of the accident taking place is not disputed. Then Your Lordship will find the paragraph 24. Paragraph 24. That on 11/6/2014 at about 9 p.m. the deceased husband of the claimant was driving a Maruti car bearing number so and so and was accompanied by one Shri Preston William of Rangfalang Mockery Block PO Thansing and was proceeding towards Shillong from Barnihat, and on reaching Nongpo proper NH 40 GS Road, the below Nongpo PS Revai district, one truck bearing number AS01DD3031 driven by Shri so and so in a rash and negligent manner dashed the car in which the deceased husband of the claimant along with one occupant Shri Preston William were travelling. Your Lordship. The accident was caused as a result of rash and negligent driving of the driver of the truck, who had driven the truck in a very high speed and in the wrong side of the road and dashed against the said Maruti car, being driven by the deceased, and as a result of which the husband of the claimant died on the spot and the vehicle was completely damaged. The matter was reported to the Nongpo Traffic Branch YGD number 14 dated so and so, but the investigating officer for the region best known to him has registered only a UD case number 12 of 2014 without recording the statement of the sole eyewitness, Sri Preston William, who was the occupant of the said Maruti car and had also sustained injuries, and according to whom the accident was caused due to the negligence of the driver of the truck. The IO had made no effort to investigate in the real cause of accident and had also failed to record the statement of the other witnesses and had registered a UD case instead of registering a regular case against the erring driver of the truck and submitted FR dated 8/7/2014. Upon receipt of the copy of the accident information report from the Nongpo court, the claimant has filed an application to the Chief Judicial Magistrate of Nongpo with a prayer to direct the Superintendent of Police Nongpo to register a regular case against the driver of the truck and endorse the same to some other investigating officer who shall record the statement of Sri so and so and other witnesses. The copy of the application is enclosed. Then this is relating to the accident, Your Lordship. Now, here my case is this, that the truck was moving in the high speed and negligently it was moving. Whereas, I'll show to Your Lordship, their case is this, that the truck was stationary. It was not moving. And the accident was solely caused by the Maruti car. Now the question which was to be determined, whether the truck was moving or it was a stationary truck. My case is this, that the truck was moving and it was not stationary. Their case is otherwise around, Your Lordship. Now in there, and another fact, Your Lordship.
So the accident happened when the Maruti car,
Sir.
it dashed, the truck from behind.
No, opposite direction. Opposite direction.
Nongpo.
Nongpo. Your Lordship, the Maruti car was coming from Banihart to Shillong.
On their left side.
On the left side. On the left side. And the truck was coming from Shillong to Banihart side, opposite direction. Opposite direction.
But that means on the wrong side of the road.
Wrong side of the road. Wrong side of the road. Your Lordship, that another thing, Your Lordship, in subpara 4, I have stated that I have filed an application before the CGM for re-investigating the matter, and that petition was allowed, and the order was to register a regular case against the driver of the truck. But quite unfortunately, for the reason best known to the police, they have not registered the case against the driver of the truck. Instead, they registered the case against the deceased driver. And no regular case, Your Lordship, can be registered against a dead man, Your Lordship.
If I understand properly,
Lordship.
if I understand from what you have submitted last time, they have registered the case against the deceased driver because of the fact that he had not stopped when he was signaled by the police.
The UD case was registered first. UD case was registered, and thereafter the FR which was submitted by the UD in the UD case was found to be inaccurate, and on my application, the court has directed the Superintendent of Police Nongpo to register a regular case against the driver. But instead of that, they have registered the case against the deceased driver, which is absolutely improper. So, Your Lordship, there are two cases. One is UD case, and the witnesses which were examined by the insurance company, they have given statement in the UD case. Now, so far the second case is concerned, rash and negligent. They, right from the beginning, they have registered wrongly against the deceased person, and made no efforts further. So this being the position, Your Lordship, the evidence which came from the opposite side, they were all evidence in the UD case, the final report of which was not accepted later on, and the court order for re-investigation of the case by registering a regular case, which was not done. Now, Your Lordship, what is the stand of the insurance company? Your Lordship, page 12. This is the written statement filed by the insurance company. Para 12. That the statement made in paragraph 8, 9, 10.
Page 12 or para 12?
Lordship. Page 12 of the paper book. 8 is repeated on 2 times. It should be 9. Paragraph 9.
Oh, paragraph 9. Yes.
That the statement made in paragraph 8, 9 and 10 of the claim petition regarding the particulars of the accident, they being matters of record, the answering opposite party denies all that which is not supported by genuine and authentic documents, and the claimant is put to stick proof. This is a evasive denial, Your Lordship. They say it is a matter of record. What record? Records are the FIR or FR, whatever includes. This is all matter of record. Then in paragraph 15, they give answer to paragraph 24. Paragraph 15.
Yes.
That the statement made in paragraph 24 of the claim petition that the accident was caused due to the fault of the driver of the truck is vehemently denied by the answering respondent, and claimant is put to stick proof thereof. It is also stated that the police have registered a UD case number so and so, and no case has been registered against the driver of the said truck, which goes to prove that the driver of the truck was not at fault, and on the ground alone the answering opposite party states that it is not liable to pay any compensation. In the written statement also they are telling that no regular case was registered against the driver, whereas there was an order. There was an order by the court that registered a regular case and investigate it properly, and by another IO, not by the same IO. Now, what he has done is not known.
Yes.
Then, Your Lordship, on page 16, issues are framed. Page 16, issues are framed whether the claimant's husband, namely so and so, died in the road traffic accident at Nongpo proper so and so, below Nongpo police station, Ribhai, involving truck bearing number so and so, which was caused due to rash and negligent driving of the driver of the said truck. So, Your Lordship, so far the factum of the accident and the death of the deceased in that accident,
Yes.
there is no denial. Only dispute is with regard to the manner into which the accident took place and whether it tantamounts to the rash and negligent driving or not. Other issues are not dealt. Then your lordship, at the time of evidence, the insurance company has filed an application under section 170 of the Motor Vehicle Act to take over the defense of the owner and driver both. The driver's defense as well as the defense of the owner is specifically taken over by the insurance company. Now, there is in this petition, your lordship will find that there are they have mentioned two ex parte order. The first, dated 9/3/2015, is the order to proceed the case.
You're reading?
Paragraph 2. That in the
Page 17.
page 17.
Okay.
That in the instant case, the matter has proceeded ex parte against the opposite party number 1 owner and opposite party number 2 driver, wide order dated 19/3/2015 and 12/2/2016, your lordship. So there is no dispute with regard to the order of ex parte, that both these people remained absent, and in absence of them, the insurance company, in absence of that, did not enter appearance, and in absence of that, the insurance company has taken over the defense. So this petition is relevant for the purpose of seeing that whether there was a ex parte order or not. There was a ex parte order. There were two orders, one for the owner, another one for the driver. Then, your lordship, coming to the evidence, I'll just point out the evidence which relates to the accident. Then, first is CW1, she is the claimant. Then, your lordship will come to page number 21, second para, that upon the receipt of the copies of the accident information report and the FR from...
Mr. General, I think we'll have to continue on next date.
Anything, sir?
You just have to sit in division bench, no?
There was no... We were under the impression that there is no DB today.
There is.
We'll assemble.
No.
We'll assemble after this.
We'll take it up on Tuesday.
So Tuesday, there are so many.
काम कीजिए. I'll be out. Lord, only problem, my lord, we are having a vacation, but then I'm not concerned about that, my lord. I have some already preoccupied area, my lord. I have a matter in the Green Tribunal at Kolkata, so, and in the Arunachal Pradesh also. So due to that preoccupation, if my learned friend give me a date so that it is convenient to me as well as him.
You suggest
7th you can fix.
7th Monday, na? Let it be on division bench. कब तक रहता है?
Division bench every day. Which date your lordship is not having DB, or all the days?
all days.
All days with one or the other.
In fact, on Wednesday I have 2 DBs.
Oh.
So Wednesday practically, you'll not be able to, because I sit in the afternoon also with Justice Bhattacharjee.
So far I am concerned, I will just take 10 minutes of your lordship's valuable
So
time.
you suggest a date?
आप एक काम करो ना, इसको 18 को रखो.
18th. It's long, yeah.
वो फाइनल है, सब preoccupied area मेरा. Lord, I am proposing.
11, sir?
नहीं, I will not be here.
अच्छा, you will not be here.
18th कीजिए. Lord, can it be convenient for your lordships to fix it on 18th?
1/8.
Okay.
And my London friend is so powerful, I have seen he has driven out everybody from the courtroom.
I'm also his student. But one thing he has taught us in college is
Right.
not to be biased.
I thought we will finish today.
Because we have DBs.
He gave me an impression that it's a single bench will be sitting. So I was so happy.
One junior informed me that Monday and Friday there is no DB. So that's why we fixed it
Anyway,
accordingly.
we can't quarrel about all that.
Heard Mr. PK General and the counsel along with Ms. for the appellant. Hearing is not concluded and will continue the next date fix. Mr. Sharma and Supritu appears for the respondents.
That we on the first item, Your
As
Lordship.
prayed for, this is matter on 18th
As a first item.
as first item in the hearing list.
He can cut short the matter. He's going unnecessarily here and there.
It's up to you. I cannot control you.
Yes.
Whatever you say.
We are greatly moved by your Lordship's simplicity, my lord.